So while many employers understand that they can be liable for the conduct of their employees, what many employers don't understand is that they can be liable for the conduct of service providers. And you might ask, well, how does that work? Well, under the Fair Work Act, a person that's involved in the contravention of another employer's breaches of the Fair Work Act is taken to have also committed those breaches. If I could just put that in context, some examples where that might arise might be where you engage a labour hire provider to undertake work, or you outsource work to another provider. It's in that context where you could be found liable for the conduct of the service provider. Two recent cases that highlight this potential liability. The first one involves a supermarket chain and its arrangements for the collection of trolleys. The supermarket chain outsourced the collection of trolleys to a third-party provider. Now, that third-party provider entered into arrangements with its employees that provided for them to be paid less than minimum rates required under our scheme. In that case, a prosecution was commenced against the supermarket chain, and it was argued that the supermarket chain should be held liable for the conduct of the trolley collection service provider. Whilst that case did not get to final hearing, the supermarket chain entered into an enforceable undertaking through which it agreed to make good those underpayments and change its arrangements around contracting trolley collection services. Another recent example is the situation with 7-Eleven. In that case, it's a situation of franchisor and a range of franchisees, and it's alleged that the franchisees are breaching a number of minimum pay obligations in respect of workers. Now, it's possible under that arrangement for the franchisor to be held liable for that conduct that the franchisees are engaging in. Now, to be liable, the franchisor would have to be knowingly concerned in those breaches, which would require the franchisor to have knowledge of those breaches and to refrain or do nothing to respond to that conduct. So employers should take a range of steps to deal with this risk. And it's important that they do take steps because the penalties can be significant. For a company, the penalty can be $54,000 per breach, and for an individual, the penalty could be $10,800 per breach. And the sort of steps that an employer should undertake include, at the point of engaging the service provider, undertake appropriate due diligence to ensure that that service provider is complying with their legal obligations under the Fair Work Act. When entering into the terms of an agreement with the service provider, make sure it's clear that the service provider will comply with those obligations and that you have a mechanism to ensure that compliance is occurring. You also need to make sure that when you enter into that contract, that you're entering into a contract on terms that would allow the service provider to comply with their obligations. You should have an audit mechanism to ensure that whilst the arrangement is working, that you are checking that there is compliance arrangements in place. And if you do all of those things, your risk should be properly managed.